Peru Cooper. Mr. Cooper is before the court on 2024 CR 07029 for two counts of terroristic threats and acts. He's before the court for the motion to revoke bond that was filed by the state. The state is represented by Assistant Solicitor Jameen Hagler. The defense, Mr. Cooper, is represented by Taz Taylor, attorney from the law firm of Lister, Holt, and Dennis. Both parties have announced ready. The states can go forward. Ms. Hagler, you can call your first witness.
Thanks, Your Honor. And before I do call my first witness, I'm asking the court to take judicial notice that the defendant did receive an order for bond for his terroristic threats charge. It was signed by Judge Kimberly F. as in Frank Bando, B as in boy, A-N-D as in David, O-H, on June 3rd of 2023. And in that order, it is checked that the defendant must not violate any laws while on bond. So asking the court to take judicial notice of that order for bond for that case.
Court, go ahead, Mr. Taylor.
Your Honor, to expedite matters, defense is willing to stipulate to Mr. Cooper's arrest on new charges. I believe that's the basis for the state's motion, and we stipulate not to the allegations themselves, but that an arrest did occur.
All right, so the court does take judicial notice of the bond conditions. The defense is willing to stipulate that Mr. Cooper was arrested subsequent to the implementation of the bond conditions. All right.
And so, Your Honor, with that stipulation, the state is asking that you do revoke the defendant's bond and that he is detained until trial.
All right. Mr. Taylor?
Yes, Your Honor. I would like to present to the court two of the witnesses to the terroristic threats charges. They are each named as the alleged victim in those cases, and they wish to address the court with information that is relevant to the charges at hand. So at this time?
Well, Your Honor, I would object. The witnesses, are you saying for the terroristic threats that you're trying to bring up to the podium?
Yes.
Okay, well, we would object. Again, we're revoking on his new offenses. So unless they are for the new offenses, we would object that the testimony will not be relevant, Your Honor. So
I'm confused. So let me understand. The terroristic threats are the 2024. What was the basis of what was the charge for the 2023 bond condition that was implemented?
The terroristic threats were the 2023 case, Your Honor.
So it was terroristic threats initially, and then another charge of terroristic threats after.
No, Your Honor, another charge. The new charge is of rape, and that was on May 12th of 2024. That is why I filed a motion to revoke bond.
Is what now?
The new charge is for a rape charge, and the incident date is May 12th of 2024, which is why I did file the motion to revoke bond. That is his new offense.
Mr. Taylor, that's a different offense. And I'm not sure that the court has to attack, that the underlying offense has to be attacked, because it's not the motion to revoke bond is not to have any additional charges. In this case, Mr. Cooper has additional charges, and so he would have violated his bond condition by getting arrested on new charges. It leaves it at that point in the court's discretion whether to go ahead and revoke the bond. The bond becomes revocable at that point that he is rearrested. The court can either revoke bond in its discretion because he has violated the bond conditions and possibly presents a risk of either new offenses, additional new offenses being committed, or he is a risk to the community at large or specific witnesses or victims. Or the court can say that it's not something that would cause for community safety to be at risk, and so the court denied the motion to revoke bond. If it's proven that he didn't violate his bond conditions, the court can also deny. But in this case, the state's going forward on him getting additional charges against him. And in that case, it's a much simpler burden of proof. You've already stipulated to the fact that he was subsequently arrested. And while I thought we were talking about an additional misdemeanor charge of terroristic threats, he has not only the misdemeanor charge of terroristic threats, but a felony charge of rape.
Well, there's not an additional charge. He was charged with 2 counts of terroristic threats.
One in 2023 and one in 2024?
No, Your Honor.
What's the 2020? So, Mr. Taylor, this is what I'm asking. If Judge Bando, who trained with me and knows her stuff, if she gave him a bond at first appearance in 2023, then there has to be a charge. So what you're saying is the terroristic threats happened in 2023, but wasn't accused until 2024. Is that what you're telling me?
Well, the 2 charges of terroristic threats were for one incident, one alleged incident with 2 victims that occurred in 2023.
Okay, so Judge Bando gives the bond conditions on the case in magistrate court. By the time it goes up and gets accused, it's accused as a 2024. That's what you're telling me.
Yes, Your Honor.
Okay, but then what Ms. Hagler is saying is that she's proceeding on the fact that he got bond conditions for the terroristic threats, but he also has a subsequent arrest for rape, a felony. So the rape arrest would have been the violation of the bond conditions, not the terroristic threats.
Yes, Your Honor. And we, as I said earlier, we did stipulate to that arrest. However, we wanted the victims of the terroristic threats to.
But Mr. Taylor, that's not how this works.
Likelihood of conviction of an underlying offense, the underlying offense and the likelihood of conviction is relevant to this, Your Honor. The victims here are prepared to testify that the event of terroristic threats to which they are the named victim did not occur. They are the witness. Okay,
but Mr. Taylor, I get that he has the right to a defense. What I'm not going to do on a motion to revoke bond is try the case. If it were the situation where he was saying that he did not have contact with the person that was named in the bond, and he can show he did not have contact, and the state is trying to prove that he did have contact with somebody named in the bond, that's a different issue. I'm going to hear evidence on both sides and then figure out if, in fact, he did have contact in violation of the order. In this case, it's much simpler. All he has to do to violate the bond order is to be arrested on an additional charge. That has happened. What I'm not going to do is, without benefit of a trial, try the case about the underlying terroristic threats. I'm going to tell you, Mr. Taylor, as until I hear it in a courtroom and I'm the trier of fact, because generally I'm usually the trier of law. So it doesn't matter to me what the witness says, as long as it satisfies a jury. In this case, I will not sit as the trier of fact on the underlying offense of terroristic threats, because he has a right to be tried by a jury. And so I'm not going to sit here and say those charges were not sufficient for an arrest. I'm not sitting in the stance of a probable cause hearing. If he had a probable cause hearing in magistrate court, they would have had the right to reduce those charges or dismiss those charges. If he didn't have the probable cause, if he waived it, or if they didn't dismiss or reduce, I'm not going to turn this into a probable cause hearing. It's either he got arrested or he didn't.
Yes, Your Honor.
In this case, he got arrested. So at this time, the court is going to grant the motion to revoke bond. Mr. Cooper is going to be taken into custody and held until such time as his charges before this court are resolved.
Your Honor, may I have 15 minutes to speak with Mr. Cooper to determine if we are going to enter a plea to the Senate's recommendation?
He can be arrested and go into the booth. If they put him in the booth, then that's fine, but he goes behind the door now.
Yes, Your Honor. She's not going to hear it.